Well, it's technically trial day 14, but it's a jury instruction day, which means no jurors, lots of law. There's a lot we need to go through with the jury instruction conference. The jury instructions get populated before trial starts on what's expected, and then they have to be curtailed to what evidence actually came in. You're going to see in the jury instructions set as they get populated, there's going to be an instruction for if the defendant testifies and if the defendant does not testify. And then at the end of trial, they go and pull certain things out. They go and line certain things out. They edit things and they decide what is going to be in the final jury instructions and argue the law surrounding that. There's case law regarding jury instructions. They get modified by committee and they are incredibly important. And we have covered at least one, if not more, appeals that are arguing the jury instructions, that the jury instruction itself is improper. And jury instructions can get changed and overturned, which can impact older cases or future cases for sure. And so the jury instructions are an incredibly important part, but the jury is out and it's not always the most riveting. We'll make it fun, but it's not always the most riveting part of trial, but it is one of the most important parts of trial we get to see. And you get to see a little bit of the wrangling of the attorneys and them thinking on their feet and using the case law and the language of the instructions to argue over what goes in and what comes out. Because ultimately, the law that is explained to the jurors is how they decide the case. And that is incredibly important.
The court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand.
Chat clocked it. Chat clocked that it was about the pill bottle. All of chat was like, it's about the pill bottle.
The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus or whatever the word is.
Detritus.
Residue. I'll use an easier word. Dust. Residue, dust at the bottom of the pill bottle. There was
the pill bottle wasn't
video
a drawer.
Or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand. And then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either. But one of the officers with gloves on holding the pill bottle took a photograph of it. The final witness of the trial, Officer Driscoll, was asked if they were able to, or still had the pill bottle. And his answer was that they no longer had the pill bottle.
It was not clear because you objected, but it seems like the medical examiner's office might have gotten rid of it, but it was objected to. And so an answer never came into evidence regarding the pill bottle because you objected to hearsay. So that's not in evidence.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No.
Not that bottle, no.
Okay.
No.
Meaning no affirmative evidence, or they don't have that bottle?
No, there was no evidence about whether or not they had it because the ME investigator testified that it should still be at the ME's office, but did not say, yes, I went and checked it out yesterday, because the defense asked in cross-examination. So you could just go get it. And the investigator from the ME's office said, should be able to. That's what they said.
I don't know that we've ever had any testimony to why it was lost or destroyed.
They didn't say that it was.
It's clearly it's gone because it would have been here if it wasn't.
They didn't say that it was.
Well, but yeah, I mean, let's come back to spoliation, right? Okay. You have to first show a violation or that a duty to preserve existed.
Exactly.
Then you have to show a violation.
Right.
Then you have to show prejudice.
Right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body. So who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial, because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is.
Ma'am, did you go to the ME's office? Because it's not in evidence lockup at the sheriff's. It's at the ME's office. Did you go to the ME's office?
The evidence is closed. Closings are happening Monday. To the extent you were a party, wanted to make an additional evidentiary showing and have the court make findings sufficient
Too late.
to
It's too late to apologize.
support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is. That time was months and months ago.
No, I disagree with that. So, I mean, we could, like, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not that.
No, we're not doing that.
Oh, the
But I'm
judge started
saying
laughing.
that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to a expert, or have it or use it at all.
Then you should have filed it when you did your physical evidence examination instead of springing it up at trial.
If the main container of potentially illicit drugs, of someone who was found dead of illicit drugs, is lost and made not able for us to recover under Rule 16,
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but keep
not
going.
right next to the body, there weren't.
It was
And,
in a drawer.
You know, there was an
It was not-
unknown.
It was not next to his body. It was in the bedroom. Fuck's
Dust
sake.
on the nightstand right where the pill bottle was could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy
Your Honor, my client tried to stage this scene better, and they didn't test it. How dare them?
in how to handle that, right? Like, one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved, and because of that, you know, you should assume that it would have been helpful to the defendant. That's the
point of all of this.
Adverse inference instruction under
That's the
Cronish
point.
versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Why is it being brought up now? Because she wants the instruction that's damaging. She wants the instruction that says, if it's gone, you can assume that it's helpful to the other side. She wants the spoliation instruction.
I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office
Right.
kept it long enough for the investigators to get custody of it. That may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
Kouri wasn't arrested for over a year. So this was just a death investigation for over a year.
Understand that this is a good faith argument, but spoliation requires findings and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and prejudice.
Right.
And we don't have that evidentiary showing. Your client certainly knew that the body was taken,
Right.
right?
And that
she
the
had an opportunity
bottles
to
were taken.
ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm
Right.
just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying.
But I want my
It puts us in
instruction,
a
Your Honor.
position where,
I don't disagree with you, but that instruction would be really helpful for us.
we might have to have, like, if,
And to be clear, you are not limited from making the arguments you just made to me
right.
to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today,
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
It's certainly not going to be closed.
No.
Okay.
We saw the arguments over the jury instructions. We learned that the defense is going to be filing motions over spoliation of the super old prescription bottle that they say was found right next to Eric Richins' body, though I don't think that's how that went in the evidence. We heard Miss Nestor say that Miss Lewis was doing closing arguments, and then we heard Miss Nestor say repeatedly, so I could argue this, I could argue that, I could argue this. I don't think I have a beat on who's doing closing for the defense. It was odd to me that she's like, oh, well, Miss Lewis can listen since she's doing closing. And then Miss Nestor's like, so I can argue, I can argue, I can argue. I guess we'll see. Watch them show up on Monday and be like, Your Honor, we'd like to split our closing. We would both like to argue. And there's not going to be a time limit on closing arguments. The limit does not exist. Because of the rule of pretty please, Your Honor, we're so ahead of schedule. So I wonder if on Monday we're going to see that the defense's representation to the court of whose closing was not 100% accurate, that the defense is still going to be arguing over spoliation, that the defense is going to file that motion like at fucking 9 p.m. on Sunday or some shit. And we will see what happens. But what else we learned is that at the very end of the charging conference, the, I think, attorney advocate for the victim's family asked that the Richins family have the ability to have 2 rows of seating in court. Each row they have assigned 12 seats for. So the public does not have seating at closing. Eric's family will get 2 rows. Kouri's family will get 2 rows. Each side will get 24 wristbands, and then they will be able to decide who can be at the courtroom. And then the odd even days of who sits where is going to stay consistent. So I think that we are going to see extended closings. I think they will go over the lunch break. I hope that closings will be done on Monday. It is possible that closings could go into the following day, depending on how long the defense takes. It is very possible that closings bounce over into Tuesday. That becomes an interesting strategy. If the defense argues over the spoliation, and we know the judge tends to not cut them off. If the defense argues in a more protracted way in the morning, then the prosecution does the first part of their closing. It's possible that we could get to the lunch break before defense starts their closing. If we get to the lunch break before the defense starts, I think we could see the defense use the rest of the day, and then the prosecution do their rebuttal on Tuesday morning, and then do the final instructions, which generally take about an hour, if not a little bit more, on Tuesday, and then give it to the jury to deliberate on Tuesday. So it's possible that we see closings bump over into Tuesday. And if I was the prosecution, I would be looking at the clock to embiggen my closing to push the defense into the back half of the afternoon so that I could do rebuttal the next day when the jury's fresh. I 100% would do that because the defense has shown that they have been a little bit long-winded, and I would not want to squeeze the rebuttal in on Monday afternoon and hold the jury longer. I would rather let the jury go home a little earlier. So I would also not be speeding up the judge's decision on that spoliation. If the defense is arguing that, I would let them just keep arguing it, and I would try to push their closing to after lunch. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.